Good evening, everyone. We're just waiting for everyone to filter in through the waiting room. We should be getting started in about 2 minutes. So now's a great time to grab a glass of water or a glass of wine and get ready. We should be ready to roll in about 60 seconds, 90 seconds. I love it, Kate. We were like interviewing, Dave and I were trying to figure out what song that we would play as the intro to a Wills and Estate seminar. ChatGPT came up with some very weird. Oh, here we go. This was the best option according to OpenAI. We like this Lil Rod Stewart, Forever
Hi.
Young.
Oh, I love all these people saying hi. They're ready to interact.
It's the only time they get to talk with a lawyer without being charged for it, Kate. There's going to be
Oh,
lots of
right.
chatter tonight.
We're not that bad. We will talk to you. It's hard not to dance to Rod Stewart.
I hate to ask, but is Rod Stewart still alive or is somebody probated his estate?
I think he's still here.
He is still alive.
Good.
Okay. We did just on this topic. I don't know who it was, but like Prince didn't have a will. There was someone very famous that did not have a will when they passed away. Al, was that, do you know, was it like Prince? It was somebody that was like very high up in the music business.
Yeah, I'm not sure if it was Prince, but I think I know who you're talking about. Is it the same person that also had a handwritten will? Was it a,
Yes, I think so. Yeah. But I guess if you're, Aretha Franklin is somebody telling me. But no, Rod Stewart is alive and well and performing in Hamilton.
All right.
Good to know. Okay.
Let's go.
All right. Dave, I'll get you to wind down our music. Thank you. Thank you. And welcome, everyone. So, as you may know, my name is Carol Foderick. I am the broker owner of Signature Elite Realty. And I want to thank you for joining us this evening. We are so glad you're here. Tonight's masterclass is going to focus on a topic that touches every family at some point. And yet it's one that most people tend to put off for far longer than they intended to. So I'm talking about wills and estate planning. For many of us, it's one of those things that just kind of sits quietly in the I'll get to it eventually pile. But as you know, life moves quickly between work, family, responsibility, caring for your home, just everything else, Netflix, everything else that gets our attention. It rarely feels urgent enough to deal with. But over the years, I can tell you that as a real estate professional, working closely with families through major life transitions, buying homes, selling homes, downsizing, and sometimes helping families navigate the sale of a property after loss, I've seen just how much different it makes when we have a clear plan that is already in place ahead of time. When documents exist and everything is organized, families and your loved ones have clear direction. Decisions are clearer. There is far less uncertainty at a time when emotions are already running really, really high for people. When those plans are missing, when they're incomplete, or if they're outdated, the process is a lot more complicated and sometimes a lot more expensive than it needs to be. And that's exactly why we host sessions like this here at Signature Elite. So as real estate professionals, our role often places us at the intersection of many important financial decisions. But our goal in inviting you here to sessions like this tonight is to really help create a more holistic approach to the advice that you're receiving, connecting you with trusted professionals like Corman and Company, who I'm going to introduce in a minute, and the information that support every part of your financial life, not just the real estate component. Real estate is often one of the most significant assets that families hold. And with thoughtful estate planning, it can just play a really, really important role in protecting that asset and ensuring your wishes are carried out clearly and efficiently. So tonight's session is designed to take what often feels like overwhelming legal jargon and make it a little bit more understandable, whether you're creating your first will or from the pre-questions I can see, there's a lot of people with somewhat more advanced questions. We are so fortunate tonight to be joined this evening by Kate Grossi and Al Gangani from Corman and Company. So this is a law firm that is in our preferred vendors list. They have been for a long time. They specialize not only in real estate, but also in estate planning and estate administration. And they have a wonderful ability to take complex legal concepts and explain them in a way that is straightforward, practical, and easy to follow. So I'm very grateful to both of you guys. You've also generously agreed to sponsor a special giveaway. So if you guys stay right until the end, one attendee who is present and live on the Zoom call at the end is going to receive a standard wills package valued at over $1,300. So someone tonight is going to walk away with the clarity and the certainty that they're going to need to be able to carry them forward, which is great. So before we begin, I just want to also mention to you that the signature Elite Realty agent who invited you to this event will be following up with you after the session just to see if you have any questions or if there's anything that we can do to help you. And of course, we can connect you directly with Kate or Al. And of course, guys, we are never too busy for your real estate questions. This is a market that raises sometimes a lot of questions, a lot of hysteria, a lot of misinformation. So I want to be clear, if you or anyone you know is thinking about buying, selling, or investing, leasing, or just wants some clarity around what is going on in the market, it would be an honor for someone from this brokerage to be of service to you. So thank you for joining us tonight. We appreciate you being here. And with that, I'm going to turn things over to Kate and Al to begin the session.
Thanks, Carol. Welcome, everybody. Is my screen share showing now, Dave? Can we see?
No, just you and your beautiful red lipstick,
Just
Kate.
me. Okay, let's see what's going on then. Let's try this again.
So while you're doing that, Diana Baggett has confirmed that the artist formerly known as Prince did not have a will.
I did see that.
I love it.
Very good. Very good.
There we
So,
go.
thank you for coming and thank you for having us. We're going to walk you through 4 areas to do with estate planning, life planning, and then at the end, we're going to answer some questions that were submitted, and Al and my contact information will also be at the end. And we are happy to talk to you if there's anything that comes up during this conversation that you want to have a further conversation about, or if you do want to start your wills and estate planning. So we're asking you to leave a legacy, not a headache. And we're going to give you a guide to protecting your family, your assets, and your peace of mind. So Al and I are going to take turns, and Carol's going to jump in with some real life examples and, great stories, and I'll get us started. So
I think we're going to have fun tonight, Kate. I know that this feels like a very dry topic, but when you start the practical implications, some of the examples, I think you're going to see that it's something that we can approach with a little bit of humor tonight too.
Absolutely. It feels like a serious topic, but it is a relief and dare I say a happy feeling at the end of it, because you're set up, you're ready to go. You can review it again in a couple of years or if things change in your life, but there is a great feeling of accomplishment when you get this done. I will confess I am 47 years old and I just finished my will and power of attorney.
And
So-
you're a lawyer, Kate,
and I'm a
you're
lawyer. I'm a lawyer. It's the shoemaker has no shoes. But when I finally did it, I know that it's safely tucked away. I know that when I'm going away, I don't have to worry. I know that if something happens, my husband and my children don't have to run around and have an added burden of trying to figure out what to do. So here's the 4 topics we're going to go through tonight. We're going to talk about powers of attorney, the will itself, some estate planning. So that's the advice piece, as are there ways to structure your estate that we can avoid everyone's favorite topic of taxes? And then we're going to talk about estate administration and what the executor's role is. Like when you're picking someone to be an executor, what does that actually mean? What do they have to do? So I'm going to start us off with powers of attorney. What are these and what do they do? So just for, strange legal jargon, and we will stay away from it, the person that you're appointing is actually called an attorney. So that is, you're not a lawyer, but you are the attorney. You are picked by we call you a donor. So you choose who your attorney is for your life and for your medical decisions and your finances. So first, we'll talk about what they are. So, powers of attorney are really simple documents, and I'm a huge advocate of doing these even if you're not ready to do your will. And that's what I did, and I can't believe I had to do that, but that's what started the ball rolling for me is I went, I can do power of attorneys in 10 minutes. So, I'm going to do these now and get those done and put them away, and that motivated me to keep going because the will decisions are a little bigger, they're a little more planning ahead, forward looking. What if this happens? What if that happened? But a power of attorney is really a straightforward document. I don't know if you can see it in the chat because we put that in the chat, right? Or Dave is going to put it in the chat, the Ontario court forms.
So right at the very top, everyone, if you scroll all the way to the top, Al has posted in the chat a link to publications.gov.on.ca. And maybe, Al, you can tell us what that is.
So that is a link from the government of Ontario, and if you're able to access it, if you're able to download it, it'll provide you with a booklet, and that booklet explains what powers of attorney are, how they're used, and also include forms. The two types of powers of attorney, one for property and one for personal care. So when you download, when you access the link, it'll provide you with a download, and it'll be a PDF. It includes the booklet and forms that you can fill out. They're the actual powers of attorney, and you can fill them out, and you can have them witnessed, and they're legal and they're valid.
They're legal, they're free. You don't need to come to a lawyer. So if you do anything, if you're not ready to start with a lawyer and you want to do these free forms that the government puts out, because they're so important that the government wants you to have them for free. Take them, fill them out. They're pretty easy to follow. So we wanted to give you that link. If you were inspired to do something today or on this weekend, have a look at that link. So if you look at that, or just generally, powers of attorney are very simple. They're a couple page document, and they're basically appointing someone that we call an attorney to make decisions for you. And there are two kinds of power of attorneys. I'll get to that on the next slide. But basically, the person that you pick can do absolutely anything for you, and there are only two exceptions. They cannot write your will. So you can, if you unfortunately become incapable and you haven't done a will, you're going to die without a will. Your power of attorney cannot do one for you. And they also cannot do medical assistance in dying. That has to be something that you choose while you're capable. It's not something that they allow you to delegate to an attorney under a power of attorney. But everything else they can do. They can go to the bank, they can sell your house, they can talk to the doctors. They're very, very powerful documents. They're simple, but they're basically choosing a stand-in for you. And that's why you need them. They can be used if you're still capable. Before everything, went online and we could do all legal documents over video and DocuSign, people used to use them because they were traveling. I'm going to be in Saudi Arabia, so I want my daughter to sign for the real estate sale. We used to do those quite a bit. We don't need them now because we can meet over video wherever you are and do your real estate closing. But so I find that they are used now only in situations where the person can't make decisions for themselves any longer. And that's why you need them, is so that somebody can stand in for you if you're no longer able to make those decisions. So the effective date is important. So I would say 99% of power of attorneys now are drafted to be effective the minute they are signed. And when I talk to people about that, there are some concerns about it because they are so powerful. Why I'm worried that if I sign this thing that says my daughter can go to the bank, that, she's going to go take my money. So the practical things are, please choose somebody you trust. And you also don't need to give it to them right away, right? You keep it. You keep it safe. You tell your people where your documents are, but you don't have to release it to them. Some people also leave them with a lawyer if they're very nervous. And then if something does happen, then they can contact the lawyer to get the power of attorney.
Okay, can
The,
I just interrupt and ask a question about this? So, to invoke a power of attorney, so if I'm a
Mhm.
real estate professional and I get called by somebody's daughter and they're like, I want to sell my mom's house, she's
Yep,
alive,
yep.
and I'm going to be signing under power of attorney on her behalf. I, as a real estate professional, have to establish the mom's capacity. So I've got to meet with her and say, are you incapacitated? Like whether the power of attorney is actually takes effect or not. Is that something that people need to be aware of?
So that is what used to be more common, is that they were only used in incapacity. But mom can be capable, and her daughter could still sign for her. So it is good practice to involve the mom, because it feels like the news is talking about fraud all the time now. And because they are such powerful documents and give such powers to, you know, family members and other people, it is a good idea to always involve the person, even if the child is going to be signing in a real estate transaction. But they don't have to be incapable
Got it.
in order to be used. And that's actually why we changed as legal professionals, because it used to be you can't use this unless the person is incapable. But
Mhm.
then, as you just said, the person has to be determined to be incapable. And a lot of the time, it needed to be determined by a doctor. So I had a situation, unfortunately, where the woman had a mental illness and couldn't make decisions for herself, but she could refuse to be assessed by a doctor. So we were stuck with a power of attorney that says you can only be used when a doctor has assessed you as incapable, but the woman was refusing to see a doctor. So that's why we have decided as a profession that they are effective right away. So you don't have this extra hurdle of proving incapacity to
Got
be
it.
able to use them. All right. So we talked about two different kinds, and they have funny names, but they are called a power of attorney for property and a power of attorney for personal care. So your power of attorney for property is the one that you need when you're dealing with real estate, when you're dealing with the banks, when you're dealing with investment accounts. Basically, it's I have the right to make decisions on behalf of this person with respect to their finances, their assets, their property. And then the other one is your power of attorney for personal care, which is the person who has the right to talk to the doctors, who has the right to make medical decisions for you, to talk to potentially a retirement residence, to decide that you should no longer be in your home and you need some assistance with your daily living. So they're two different separate documents. They will both be in that Ontario Power of Attorney kit, and they don't have to be the same person. Right. And you choose people that you trust, and you choose people that are up for the job. So if you have a child that is a nurse and understands medical and understands, or is a social worker and understands, you know, living arrangements and what we need to do as we get older, that person is probably a good person for a medical power of attorney. But if they do not like talking to banks, and they are not comfortable with taxes and accountants and investments and real estate transactions, then that nurse does not need to be the power of attorney for property. And if you don't have someone in your family that is skilled at either of those things, it doesn't have to be a family member. It can be a professional, it can be a lawyer, it can be an accountant, it can be a friend, it can be anyone that you think is the right person for the job. You will always choose an alternate as well. So the government form will have a substitute fill in the blank. So this is part of the planning, and the planning ahead is, what if the person I picked can't do it? You know, what if a typical situation will be I pick my spouse, but if my spouse is not here, maybe my spouse goes first, then my alternate is my child or my friend. It can also be more than one person. If you want two people to make decisions together, so then to have two people acting together is a good idea, as long as you trust them both and as long as you think they will work together well. You don't want to pick people that are not going to work together well. And you don't, there's a, if you have multiple children and you feel like the right thing to do is name all your children, I understand the kindness and I understand the logic and the way of thinking in that, but it might not be good for your children that they all have to agree on something. And, part of estate planning is talking to your family ahead of time. So, my father, when he was doing his will, told us that the three of us would be executors. And I was actually quite shocked by that because I thought I would be the sole executor. And it's a funny thing, but the fact that he communicated it ahead of time and, why he wanted that. And I get along with my siblings, but it was just my expectation did not align with my father's wishes. So I'm really glad that he told me that ahead of time, told all of us that ahead of time, instead of us finding out at a later date. The more sensitive subject, which I'm also really glad that he talked to us ahead of time, is I have two special needs children, and he would like to leave them something set aside for the two of them. And, I think the expectations for all of us was that his estate would be divided equally between his kids. I was really glad that he talked to my brothers and I because I would hate for my brothers to feel like I got more because my children were included in his estate. And they now have the opportunity to talk to me or to talk to him about it if they do have, a question or an opinion about that. So communication, whether it's in the estate planning to the beneficiaries, to the executor, or whether it's in the estate administration, which Al will talk about in a bit, to the beneficiaries, because beneficiaries don't know what the executor is going through. They don't know the timelines. They don't know the work involved. And they feel like if you're not communicating with them, that they should be panicking and you're not doing a good job and they need to be following up with you. So communication in all of this, in the estate planning and the estate administration, is key, even if it's slightly uncomfortable, because who wants to talk about this? But it's really good to do.
Okay, we were talking about this before. It's also something to be mindful of is like when you choose an estate executor and you're going to have multiple estate executives, you're also inviting the opinions of the spouse in, not legally, not officially, but to be clear, if you have somebody that is married, so you've got three kids and they're all married, it is realistic to believe or to know that somebody is going to go home and discuss the matters of the estate with their better half who is going to have opinions about what should be done. And this
Right.
is where it gets, so it may be not three, it's maybe six, and you can't direct who gets talked to about this sort of thing. It's really not possible. So I agree with you, Kate. Some of the messiest estate situations that we deal with as real estate professionals also usually involve too many people
Right.
really being involved. We needn't have six people making decisions about, and some of them not even living in the country, like having no ability or knowledge of the Canadian legal system. So it can get a little bit complicated sometimes. Be really intentional. It's not a reflection of which child you love the most, or I love all my kids equally, so I'm going to make them all executors. Really be intentional about who's going to be your executor.
Exactly. Exactly. And if you have those conversations up front, then it relieves you of any sort of uncomfortable after the fact unmet expectations. So I just wanted to talk generally as well about what your responsibility is if you are named someone's power of attorney, because the law holds it to a very high standard. It's called a fiduciary duty. So because it is such a powerful document, because you can do anything essentially for that person, you are required to always be diligent, honest, act with integrity and in good faith. So you cannot make any decisions that benefit you over other people, right? You have to always make it with the person's best interest in mind. There is certainly power of attorney abuse where, a rogue child has the power of attorney and they're dipping into the parent's bank account. That is going to come out in the wash because any beneficiary of an estate can ask for an accounting. So if you were named someone's power of attorney, you have to have records from the minute that you started acting as to exactly what you did, what you paid, what you took out, where it went, because it all is can be requested by a beneficiary of an estate. I want to see exactly what you did from the minute you took over mom's accounts. I also wanted to point out, because I think people don't always know, because these jobs are a lot of work, that there is pay for this work. So a power of attorney, I think it's 3%, right? 3% in and 3% out. So basically, if you take over someone's power of attorney and you're doing all this work, it is a lot of work, and you get paid 3% of what the money that is coming in that you're managing for that person, 3% of the bills that you are paying, and also it's a 0.6% care and management fee. A lawyer will help you. You don't have to take pay, but I always talk to people about it because I see how much work it is. And we can also specify in the document, and we can talk to the person giving the power of attorney about this compensation and about this pay, because let's say it's 3 siblings and one is doing all the work and the other siblings are sitting back, but they're also going to be mad that the sibling that's getting the work is getting pay. We're going to put it right in the document that mom said, I chose X and I've approved them getting paid for doing this work. All right. So now we're going to talk about what if you don't fill in this Ontario form and you become incapable and there is no one chosen to make decisions for you. So when it comes to property, you are completely stuck. So if I do not have a power of attorney, I have a corporate bank account that's just in my name. My husband can't access it. It's going to sit there. He's going to have to do what's called a guardianship application. And these are basically an application to the court. So my husband would have to make an application to the court saying, I'm her husband. I need to access her assets. Here's a list of all her assets. Here's what I'm planning on doing with it. They have to submit something called a management plan. So it's a massive legal bill. So you can do power of attorney for free right now using that form. If you don't have it, then we've got a $10,000 to $15,000 legal bill. It might be someone that you would not have picked to be the person who's going to manage your property, because it's going to be a judge that decides, and it's going to be delayed. I would say that you can rush a guardianship because of the necessity of it, but I would say minimum 3 months that my husband would not have access to any of my assets. With a power of attorney for personal care, there is a hierarchy. So if something happens, you're not able to give instructions to a doctor or to medical staff, the law sets out these are the people in order of who get to give instructions to the doctors. So we do have that for a power of attorney for personal care. Again, what if these are not the people that you would pick? And again, if it's you have 6 children, they're all equally going to have a say. And that can complicate the process if they do not agree. And no one likes that the government is an option if none of those people are available. Okay, so I'm going to turn this section over to Al, and he's going to talk about wills, and we're going to tell you where to start. And Al was just generally, Al and Carol and Dave and I were talking earlier. Al can do your will and complete your estate planning in 2 to 3 weeks once he's got all the information that we need to do ahead of time. It is a bit of an exercise. You have to make a list of what you own, but it's a very good exercise, because if you pass away without a list of what you own, even if you have a will, how does the person know that you have an RBC visa and who your car loan is with, and that you have a rent-to-own fridge from Leon's, or if they even still exist. So Al, I'll hand this over to you, and you can start talking about wills.
Thank you, Kate. Good evening, everyone. So we'll start with assets. One of the first things you want to do when you're in the process of preparing your wills is to make a list of your assets. You want to know what you own. So make a list of all the assets that you own. Where are they located? And how do you own it? There are implications for that. When you know what assets you own, you can structure your will and your estate plan effectively, so that assets can be transferred seamlessly. When you take a look at some of your assets, you may find that if you have assets in different jurisdictions, so for example, if you own a house here and maybe a home in Florida, your estate planning could change. You could, in that situation, you'd want to have a will in Florida and a will in Ontario. You can have, when you know what assets you own, you can structure your estate plan to make it effective and easy for your executor to deal with and for your beneficiaries to inherit those assets. How do you own it? When you own assets, there are tax consequences based on how you own it. So if you own an asset jointly, you can avoid paying probate taxes. So for example, if you own your primary residence, if it's jointly owned with your spouse, it'll pass directly to your spouse and you can avoid paying probate tax. However, if the home is only in your name, then it will go through probate. And probate right now in Ontario is 1.5%. And so the value of the home would be taxed. So it's so important to know the assets that you own, where are they located, and how they are owned. The most common categories of assets, and this is with most people, and it's usually real estate, bank accounts, registered investments like RRSPs, TFSAs, RDSPs, RESPs, non-registered investments, so checkings account, savings accounts, life insurance policies, pension plans as well, and personal items of significant value.
Al, a couple of questions just from the chat, and this might be taking a quick step back, but I know they're like very quick answers. Can I assign my sister in the US as a power of attorney? Kate, do they have to be in Canada to be a power of attorney? Yay or nay?
They do not need to be in Canada, but we have to be practical because can she come up and talk to and have a meeting at the bank?
Yeah, a
'Cause
bunch
they're
of this stuff does have to be done in person. It's very difficult
right.
for some of these activities to be done. And then second of all, does the power of attorney, does the power of attorney, so the one that we've included, does it need to be notarized?
No,
No.
it needs to be witnessed.
Needs to be witnessed, not notarized. That's helpful. Thank you. And for the power of attorney for personal care, what age do the children need to be able to make those decisions? Is it 18?
Correct.
16.
16?
To be someone's POA, you have to be minimum 16 years of age for POA for personal care, 18 to be someone's POA. But in order for you to make your POA, you need to be at least 18 years old.
I understand. So if you are a parent and you would like to name a perhaps not quite adult child, but somebody that you have say you're a single mom and that's the only person you're related to in the world, you can allow your 16-year-old to make personal care decisions for you.
Exactly. For your POA for personal care, you can appoint someone who's 16.
Yeah. And I'm told to ME banks, it's not required to have a notarized power of attorney document if you're using the Ontario one.
So the bank will want to see either the original or a notarized copy of the original. So that's maybe what the question is getting at is you can't just bring in a photocopy to the bank. They want to see either the original with the wet ink signature, or they want to see that the original was brought to a lawyer. That's what a notarial copy is. It's me saying, I have seen the original and this is a perfect copy of the original. I'm going to put my seal on it. I'm going to put my stamp on it. And the bank will want to see that. They will not take just a photocopy or an email scan of a power of attorney.
Got it. Okay. So moving on to the list and decisions. And I think, Al, we were talking about the fact that this is where sometimes people get a little hung up because there's big decisions to be made here, right?
That's right. And so we'll start with the executor. Now, these are the most common elements you'll find in a will: executor, guardian clause, the beneficiaries clause, and gift. So why don't we start with the executor? This is a very, very important appointment and often overlooked. This is the individual that's going to carry out the wishes of your will. This is the individual or individuals that will be dealing with the government, the CRA, the banks. They will be the people or the person administering your estate, settling your estate. You want to make sure whoever you're picking or people you're picking, if it's people, you want to make sure they get along. And you also want to make sure they're capable of carrying out the work, because it is a lot of work. Filing for your taxes, speaking with the lawyer, speaking with the banks, If you have a complicated estate with a bunch of real estate, selling those properties, dealing with beneficiaries. What if you have beneficiaries that don't live in the country, overseas beneficiaries? So you want to make sure the individuals that you're appointing for this role are capable. It's not about who you love the most, but it's the individuals that you know can carry out the wishes of your will and deal with your assets and deal with your estate when you pass away. Guardianship. So if you have any minor children, you're allowed to appoint a guardian in your will. This is the individual that will make decisions for minor children in the event that you and the other biological parent has passed away. Beneficiaries. This is one of the most important portions of your will. Who are going to be the individuals that are going to inherit your estate, inherit your assets? You get to choose your beneficiaries. If you have minor beneficiaries, if there's children that are under 18, you can decide at what age they're going to receive their inheritance. You can pick an age, so you can say, I want my children or my grandchildren to inherit everything at 21 or at 25. Or if you prefer a staged distribution, 50% at, let's say, 21, and then the balance, the remaining 50% at 25, you can structure how you wish to leave your assets to your beneficiaries and minor beneficiaries.
I think that's really important because there is a lot of wealth transfer. There are fortunate people who have acquired a large estate, and I find it quite common that parents say, I don't know if I want my kid having $5 million at 18 years old. So it's spread over time, so that or you can write in things like, give them this much, and we can also buy them a house. We have the discretion. We can write in things that we can pay for education, we can pay for houses, we can do that sort of stuff. But basically, we're leaving the executor as essentially a trustee. So that's another important role. Executor is the old term, and I use it because that's the one that is most commonly known, but they're actually called estate trustees now. So if their executor role is not necessarily done once they've done the taxes, they can continue to manage a trust for someone for a number of years after you've passed, if some of the assets are going to stay in trust, because it's either a minor child or a disabled child, or just that you don't want a large sum of money going into someone's hands at a certain age because you don't think it's good for them.
That's
Now,
right.
I'll ask a question about the beneficiaries because this
Sure.
came up in one of the questions ahead of time.
Sure.
We had a question from one of our attendees about writing wills in accordance with Islamic law, and we sort of talked about the fact that there may be some challenges with that, but it speaks to whether or not there are laws that can be sidestepped or not when it comes to naming specific beneficiaries. So sometimes you can't leave everything to the person that you wanted to, and maybe you can walk everyone through that.
That's right. So you can try and structure a will as close as possible in terms of distribution according to Islamic law, but it may not be enforced. So say, for example, you have a spouse and you're not providing for that spouse can make a claim. And even though your will says that spouse, and you may feel that it's consistent with your religious beliefs, but the Ontario law will override that, and that spouse can make a claim. So if you're leaving your spouse, for example, a very small share of your estate, and you may feel that it's consistent with your religious views, he or she under the Ontario law can make a claim. That person can make a claim and override your wishes under your will.
And that's the case with any religious belief or not. We have a rule that says that your spouse is entitled to 50% of your estate. So if you do your will kit and you don't leave your spouse 50%, then they get we call it a spousal claim. And it's basically a claim against the estate that the executor needs to deal with that will change the distribution that you left in your will.
And they can make that election within 6 months. And so it'll hold up the entire estate. So let's say you're leaving your spouse only 10% of your estate. Your spouse has 6 months to elect whether they want to take the 10% or equalize as if they would in a divorce proceeding. So it's very important to make those considerations when you're preparing for your wills.
And we'll talk about this a bit later, but I think it's a shock to a lot of people is that spouse means married spouse. It does not mean common law spouse. That's essentially what a marriage is yes, you love each other and you've decided to spend your lives together, but you've also entered into a legal contract to give them 50% of your assets. And if you don't enter into a marriage legal contract, then you have not signed a contract with your spouse to give them 50% of your assets, your common law, and you don't have a contract to give them that.
That's right. And just to go back to beneficiaries, when you're considering who your beneficiaries are, you may also want to consider any tax implications. Mm-hmm. If you have a beneficiary overseas, there may be an inheritance tax in that jurisdiction. In terms of disabilities, you want to make sure, if any of your beneficiaries may have disabilities, you may want to consider setting up a specific type of trusts. The most common type of trust that we see, or at least that I see, when I'm making wills for parents who have children who are on ODSP, we draft what we call Henson trusts. They're a very specific type of trust that deals with ODSP recipients. It allows them to receive their inheritance without having them become disqualified from receiving their ODSP payments. Let's move on to gifts. So when you're structuring your will, you can leave gifts in multiple ways. You can leave cash gifts. So you can leave what we call a legacy gift. So, an amount of $50,000 or $100,000, or you can leave what we call a residue gift. The residue gift is what's remaining after debts are paid, taxes are paid, and after specific items are paid. When you're structuring your will, you want to make sure you give away 100% of your estate, because if the entire estate has not been distributed, you may have an intestacy issue, and that's a problem you don't want to go down. We recommend when you're structuring your will to have a residue clause, and when I draft wills, we always include a residue clause. You can always, like I said, you can always include cash gifts, gifts to friends, family members, charities, but always have a residue clause. And then that residue clause will deal with all the other assets that you haven't specifically included in your will.
And I think that is so common, and I understand it. When I get instructions to draft a will, the instructions will be, I want to give this amount of money to this person, I want to give the cottage to this person. And we don't want you to write it out that way, because if your assets are always changing. So you're going to have to revise your will every year, if you sell the cottage or if your value of your investments has gone down or up. So what we always advise is instead saying, take everything I have and split it amongst these people. And then whatever you have when you pass, we're not trying to forecast what you're going to own on the day you pass away. We're going to say, what I have left, I want divided this way. And the other reason we want that is because we have to make room for the tax liability that you're going to have when you pass away. If you say, give my cottage to my daughter and give my son my investment account, they're both roughly, equal. Well, then we haven't specified where the taxes are getting paid from. Then you have a deficiency in your will, and then they can fight about if the taxes are supposed to come out of the cottage. Are the taxes supposed to come out of the investment account? Is it different because the taxes are higher on the cottage than they are on the investment account? We want to avoid all of that by, instead of doing specific gifts, by doing shares or percentages.
That's right. And just to add to what Kate said, if you're thinking about, say, for example, leaving your home to one child, and then the residue, which is everything else, which includes all the bank accounts, the registered accounts, and roughly they're both equal in value, you have to remember that if the child is receiving the home without a mortgage and it's a free and clear home, all the other taxes, all the other liabilities will come out of the residue. So the child that's getting the residuary gift is going to end up with much less, because all of your debts and taxes are going to come out of his gift or her gift. It's going to come out of the residue. So when you're structuring your will, you want to try and be as equal as possible, if that's your intention. If you
Mhm.
provided for one child during your lifetime more than the other, then you can leave a note in your will, or you can explain those intentions to your children while you're still alive. But generally speaking, you want to treat your children equally.
And I think this is important conversation. Al, you mentioned a really specific circumstance with regards to taxes payable. And
Yes.
I had a client of mine, and the will said that. And again, it was a basic will kit prepared online. It was that one child is getting the cottage and the other child is getting everything else. And the
Yes.
approximate value of the cottage was equal at the time that it was written, was approximate to the value of cash in the estate. Now, the
Mhm.
challenge is that, mom passed away during COVID, and the value of the cottage had gone up from 250,000 when she wrote the will to about $1 million. And
Right.
Wow.
so it was now no longer an asset worth 250 and cash worth 250 divided equally. It was a cottage worth $1 million. The
Yeah.
capital gains on it was the entirety of the rest of the estate, and it was
Exactly.
required to be paid out of it. So you had one child with $1 million asset and the other child with nothing.
That's
And so
exactly what we want
so
to
just be
avoid.
mindful of that, guys. And we talked a little bit. There's a lot of questions in the pre-submissions about using an online will kit, and maybe this is a good time to just sort of address that, because there is a time and a place to use them, but you do miss other key components, and maybe you guys can just walk through that, because a lot of people asked about online will kits.
Yeah, and I think it's a really good question. And honestly, I've never been on an online will kit. I'm sure they're designed, like TurboTax to help guide you to draft your will. So, my advice would be, if you're not going to do will because it's prohibitively expensive to go to a lawyer and do that, then do the online will kit. It is better to have a will than to not have a will. And I would say they're probably okay for a straightforward estate. But the example that Carol just gave, someone would think that that is a straightforward estate. But look at the consequence of what happened. And hopefully, the child who got the cottage says, "This is not what mom intended. Of course, I'm going to share, but do they legally have to? No, right?
Spoiler alert, Kate, they didn't.
They
So,
did.
no, no, someone's enjoying their lakefront cottage right now, and somebody's pretty sour about how that all turned out. So, yeah,
Right.
and I think that
So,
that's unfortunate. Like, money, and especially huge amounts of money and disparity can leave a wake of hurt emotions behind it, I think. So, but thank you for pointing that out.
and that's another reason as to why we do these shares, right? Is that because the value of the cottage changed, and the
That's right.
investment account, maybe mom lives forever and it's completely drained, right? So, from a cost perspective, if we do the shares or the percentages, you don't have to do another will if nothing has changed, right? The values can go up and down, it doesn't matter. It basically just says what I have when I die, split it equally between my kids after the taxes are paid,
And
right?
you can make provision if it is really important that one child
Of
ends up with a
course.
cottage, make provision that they have first right of refusal.
Yeah.
But then the assets are equal, and then they can choose whether or not they want to invest their parts of the inheritance back into the cottage and pay it out. So,
Perfect.
so moving on, because I know we're running short on time. We've got about 15 minutes before we get into our question and answer. So Al, I'm going to
Okay.
ask you to go through this.
Yes.
Yeah.
Okay. So what happens if you pass away without a will? Now, lots of people in Ontario pass away without a will. In that situation, the government created rules. We call them the rules of intestacy, the rules of intestate succession. Um, Someone would have to apply to be your executor. Someone would have to step up and apply to be your executor. You don't get to pick. Someone's going to have to step up and apply to become your executor. If you have minor children and both biological parents have passed away, someone is going to have to likely apply to become the guardian of your minor children. And if no one is willing to step up to be your executor, or if no one's willing to become the guardian of the children, then the PGT, the public guardian and trustee, will likely have to step up and fulfill those roles that no one's willing to take up. Beneficiaries and gifts. The government created rules as to who will inherit your estate. And these might be people that you don't want to inherit, that you don't want to leave your estate to. But the government created a hierarchy. The next of kin will inherit your estate if you passed away without a will. And the next slide will show you And I'll go over who gets to inherit should you pass away without a will. If you have a spouse and your estate is worth less than 350,000, your spouse will inherit everything. If your estate is worth more than 350,000, your spouse will get the first 350,000. We call this the preferential share. He or she will receive the first 350, and then everything else will be divided among her and then any children. If you are separated from your spouse for at least 3 years, they will not inherit anything. If you have a common law partner, they are not entitled to inherit anything if you passed away without a will. They can make a claim for dependency support if you were looking after them, but under the rules of intestacy, government rules, they're not entitled to inherit like a married spouse would. And children will only inherit if there is no spouse.
I had a client that was killed at his place of work, and he did not have a will. And of course, he wanted his spouse and children to inherit, and they did. But the practical problem is that the wife got 350,000, and then she got a third of what was remaining, and the other 2/3 had to be held in trust for the children until they were 18. So the husband was the income earner. 350,000 and a third of the remainder, with 2/3 of it being held in trust, was not enough for her to keep the house, keep paying for the kids' school, support the children while she's going through this terrible grief. So even though this hierarchy might sound like, okay, like it's sort of in line with what we would like, in that if you have minor children, the spouse does not have access to that minor child's share to help support that child while they're growing up.
So bottom line, have a will, especially if you have children. I'm not saying that it's the only reason to have, a will, but if you have children, it's really a non-negotiable in terms of who will care for them, how they will be provided for. It's a non-negotiable.
And especially if you're common law. What a tragedy that you've been with someone for 40 years and they do not inherit because you're not married.
That's
Okay.
right.
And then these are the ones, Al, you can do these quickly. If
That's right.
spouse, no kids.
Yeah, so if you pass away and there is no spouse and no children, then your parents will inherit equally. If your parents have predeceased you, then your siblings are next in line to inherit your estate, all of your assets. And if there's no siblings, then it's nieces and nephews. And if there's no nieces and nephews, then it'll be your next of kin, so closest blood relatives. And if the government can't locate any next of kin, if there's no one else to take up the estate, then the government inherits your estate.
I'll just point out, guys, because this is a story I tell a lot as a cautionary tale. We had a situation like this years ago with real estate, and it was there was no estate, there was no will, but the person passed away, and it was apparent that they had a brother that had predeceased them, and that brother had an adult child living in the Ukraine that they had never met before, and the estate executor, who was another niece, was tasked with trying to locate that other beneficiary, and it tied up the estate for 7 years before they could finally disperse, because they were aware that person was there, that person existed, but they needed to determine whether or not person was alive or dead. They could not determine whether that person was alive or dead, and so that money was turned over to the government after 10 years. And so it is a nightmare, guys. Please, if you take nothing else away, please get a will.
Yeah.
Perfect. All right, so we'll just quickly do these estate planning tools. These are
Yes.
things that the reason that you
And then we're
may-
going to get to all these questions because people
Yes.
love to get free legal advice. So we're going to figure out how to keep your conniving son-in-law from owning your cottage.
Perfect, perfect, perfect. So this is the reason we have you make that list of your assets and where they're located and how you own them, because there are a few structuring tips that we can do to try and avoid probate tax. And I don't think probate tax is terrible. It's 1.5%, but we don't like paying tax. So if we can avoid it, let's do it. You will not be able to avoid income tax and capital gains. Like when you pass away, if you have an asset that has increased in value, you are going to have a capital gains tax on that. There's no way around that. But probate tax is where most of the planning is. And essentially what we try and do is we try and see if we can move assets outside of your estate so that they're not subject to this tax. So it's 1.5%, so $15,000 on every million. And then there is no inheritance tax in Canada. I think people confuse the deceased income and capital gains tax. When I pass away, all of my assets, if I've made money and they're not tax sheltered like an RSP, I have to pay a capital gain on the increase in value in my assets. That's my estate. That's me paying the tax. It's not my beneficiaries who receive the net proceeds paying the tax. So these are some of the tools that we look at when we're looking at your list of assets. We consider whether your assets are held jointly. A typical question, I think even one of them was, do I add a child onto my bank account so that they can inherit? Yes, you can do that. If you are leaving, if you have two children, put them both on, right? So then they can equally inherit. I don't want just one child on there and then they're getting the bank account and the other child is not getting the bank account. So we look at whether we can hold assets jointly. Life insurance and registered investments have designated beneficiaries. So when you set up your RSP, they will ask you at the bank, who's your beneficiary? You put it on that form. You probably never think about it again. It's important when you're doing your will to revisit that and make sure that that designation is there. Maybe you need to update it. But the importance of those sort of assets is you don't pay probate tax on those. They will go straight to the beneficiary. So if you have an RSP, it's got $1 million in it when you pass away, it will go straight to the beneficiary without that $15,000 in tax. You can also give property while you're alive, right? If you know that you have enough money to last you until you are 200 years old, start giving it to your children now. And then you can also have multiple wills. So I have we call it a primary will and a secondary will. What goes in my primary will is assets that I know need to go through probate. So real estate, bank accounts need to go through probate. My shares in my corporation do not need to go through probate. They're in my secondary will. My personal property, if I have a tiara that's worth $100,000, that will be in my secondary will. I don't have to pay probate on that. So we can do multiple wills to structure it so that there are assets that must go through probate and assets that don't need to go through probate. Do we have 5 minutes to talk about estate admin before questions?
Yes, absolutely. Yeah,
Okay.
an important consideration.
Okay, Al, you're up.
Yes. So we'll move on to the next. Oh, perfect. So just like I talked about earlier, being an executor, it is an honor to be someone's executor, but it is a lot of work. You're carrying out the wishes of the will. You're dealing with the estate. You're settling the estate, and you're wrapping up the affairs of the deceased. Consider it like being the project manager of that person's estate when they've passed away. My suggestion to anybody who's structuring their wills, who's preparing their wills, like I said, you want to make sure you appoint someone who's capable of carrying out that task, because ultimately the beneficiaries are going to be waiting. We want to make sure the beneficiaries get their, receive their inheritances. We want to make sure taxes are filed. We want to make sure the estate is settled without any delay, without any issues. Everything is transferred smoothly.
And again, like attorneys under power of attorney, there is pay for being an executor. And because it can be a hot topic, you can put that in your will so that this is what mom or dad chose. They chose me and they chose that I would get paid for this work. If it's not specified, the guideline is 5% of the value of the estate. And of course, that depends on the amount of work involved and the size of the estate. And the executor fee is income. So there is tax that you will pay on that. So sometimes we structure it as an additional gift in a will instead of an executor fee so that there is no income tax on it. So there's ways to do that as well. And you can also resign if let's say mom made a mistake and she put six executors on her will. She wouldn't listen to the legal advice and she put six. Um, you know, people can say, you know what, I'll just back out. This is getting crazy. There's six
And
of
to
us.
be clear, Kate, that doesn't forego your rights as a beneficiary. It just means that you choose not to
Absolutely
be
not.
involved in the administration of the event.
Administration, exactly.
Got
So
it.
you can be chosen and not, and just it doesn't work in your life. Maybe you've got some very big responsibilities and you just know that you're not going to be able to do this role at this time. You can resign. You're not forced to be an executor.
I would personally recommend not having more than three executors
Yeah.
of your estate, three at the most. After three, it just becomes unwieldy. It becomes very difficult to coordinate everybody. Everybody has to work together. They're co-executors. They have to work together, and people have lives. They have work obligations, family obligations. I would restrict the appointment to three at the most. Um, just to add to what Kate said in terms of compensation, if you don't specify, what practically happens is the executor can go to the residuary beneficiaries, and if they come to a consensus and say, look, I think you did this amount of work, you can present your hours, and if everybody agrees, you can take that amount that all the the residuary beneficiaries have agreed upon.
And if they don't agree, then you can go to the judge and say, they're not agreeing to my pay. Here's what I did. What do I get paid?
That's right. And you keep a log of all the work you did, how many hours. Most of the states take about 100 hours. So it's a good idea to log in the hours. And you have about a year. The general guideline is about 1 year to complete your role as an executor. It's not a hard and fast rule, but it is a general guideline. Some estates take longer than a year. It just depends on how complex the estate is. If you have, assets all over the world, if you have, a lot of trust set up, it could be a lot longer than a year. But generally, you have about a year. Your executor has a year to wrap up your affairs, or to wrap up the estate, to settle the estate.
And so let me
Probate.
ask you a follow-up question about
Sure.
this, Al. So if we
Yep.
have people listening today, they are beneficiaries of an estate, not the
Yes.
executor, and they
Yes.
have concerns about the way that the estate is being handled.
Yes.
I'll give you an example. I was recently in conversation with somebody. They are the beneficiary of estate. The person who is the executor of estate, mom passed 4 years ago. It's been 4 years. They have not, the house is sitting vacant. They have not tendered it for sale because they're waiting for the market to recover. What rights as a beneficiary and not as an executor do you have to ensure that your inheritance or the benefits that you're receiving are being handled competently?
That's a very good question. Beneficiaries have rights. Beneficiaries can speak to the executors directly, and I think it's a good idea for beneficiaries and executors to have a transparent, open relationship. If the beneficiaries feel that the executors are not doing their job, they're either delaying, or they're not competent to handle the role of an executor, they can bring an application before the court. They can bring an application before the court to remove them, or if they feel that their inheritance that they're receiving is too small, then they can ask them to open the books. We call them passing of accounts. They have legal remedies through the court. They can make an application to the court and bring the matter before the court and have a judge deal with this issue. But to avoid all of that, it's important to appoint a very, very good executor, someone who can carry out the tasks of your estate, because you know your estate better than anybody. You know what your assets are. You know what your assets are. And given your estate, you want to make sure you appoint someone that's capable of carrying out that workload.
Great. Thanks, Al.
All right.
Okay, so we'll just do that. Maybe we'll just leave this as a list for you guys.
Okay.
Is it time for questions, Carol?
Yeah, we've got a few coming through, but I just think it's so important, guys. Like and everybody grieves differently. And I think that's so important to understand. And I just want to talk about this because there's going to be people on this call that have been asked to be executors. There's going to be other people that are going to experience this process just as a beneficiary, or perhaps even as a bystander, like a spouse or a relative, somebody that doesn't have an official role but is impacted by this. And I'm sure you guys, also have some awareness of this. Grief shows up very differently in different people. In 25 years of real estate, I have had people call me from the hospital before they've even taken their loved one to a funeral home to talk about selling the house, and that's not from a place of greed or or anything like that. Nothing nefarious. It's just that for them, the healing process of grieving the loss of their loved one cannot start until all of the legal and the loose ends have been tied up. On the
Right.
flip side, I have other, clients that cannot even imagine going through the process of, walking into the house of a loved one until, everything has been, the person's been, properly buried and they've had time to process their emotions, and then they go in little by little. Neither is right or wrong. And so I
Right.
think that's just really important, that if you find yourself in an executor relationship with somebody else and they are processing their grief differently than you are, just be mindful. It doesn't mean there's no right way or wrong way to do this, to process grief. And the whole this whole idea of wills and estates is really comes hand in hand with giant emotions at the same time, um,
Right.
of many different layers. So I just want to encourage you guys, if I can share nothing else with you, be kind and be respectful if you are in a co-executor relationship with somebody else, that the way that they want to approach it may not be the same as the way you want to approach it, and that's okay. We need to hold space for the way that they grieve as well too. As long as, there's an eventual conclusion to everything, be mindful that these are big emotions for everyone. So that's my 2 cents. And I mention it only because there's immediate steps. Call the real estate agent to list the house sometimes it's gonna be the last thing, or it's gonna be the first thing, depending on
Right.
how you process your grief.
Yes.
Call the lawyer. I'm sure you guys get calls from the hospital saying, what's next?
Mhm.
Dad's literally just passed away. And so it's just respectful. It's just important, guys, to respect the fact that everybody is on this grief journey a little bit differently. And don't think that it comes from a place of uncaringness or caring too much. It's just all how we process. So let's get into some questions, guys. Okay, so we've talked a lot about the online will kits. I think you've touched on that. There was a number of questions involving trusts, and I want to touch on that. So this is a hot topic issue. Should I have my money in a trust? My kids are going to inherit a trust. Let's talk a little bit about that.
So for trust planning, the real advantage is the avoiding the probate tax again. So if you had a large real estate portfolio and you wanted to put it in trust, then you are going to escape that 1.5% probate tax on the real estate. So that is a consideration. It's one of the estate planning tools is should we set up a trust for any of your assets so that we can avoid the probate tax?
And so, trusts good for do the vast majority of people on this call need to know more about trusts or sit down with a financial advisor to talk about trusts, or is that probably outside of the scope of most people's?
I would say it's like a high net worth individual, which I would say, $10 million more in assets because there are reporting, tax filings, like there's a whole bunch of annual work that has to be done when you set up a trust. So you have to consider whether it makes sense depending on the type of assets you have and the value of your assets. So I would say most wills and estates clients are not setting up trusts.
Got it. Okay. And I think that's really helpful. And I'm just going through the list here. There were some questions about pets. So no kids, beloved pets. And to Walter and Roxy, if you've ever seen their dogs, they make an appearance at our annual client appreciation event. They are pretty spectacular animals. So how do we care for our fur babies? In passing. And as they point out, they maybe don't want them to inherit millions of dollars, but they do want to make sure that they're cared for. So how do we do that?
So you can set up a trust in your will for your pets. If you want to leave pets to an individual, I often draft what we call pet clauses, and in that pet clause you can include who gets to inherit the pets, and you can even set up a fund for the pets. So you can set up you can set up a trust with a certain amount of money that'll be dedicated to looking after your pets when you've passed away.
Right.
And then a lot of questions specifically around cottages as well too. And so I want to touch on this because you've mentioned already there really isn't a way to avoid capital gains per se. But the question is, what's the best way to ensure your adult child inherits the cottage and doesn't get stuck with a huge capital gains tax to pay? Is it better to transfer the property before I die? I want the transfer to be affordable for my daughter. And you know what's funny is like people seem to have the most emotional attachment to cottages.
Absolutely.
They're
Yeah.
places that have often been in families for generations. They are, hold deep, happy memories of raising your children there or swimming on the waterfront when you were a child. Um, Specifically with regards to cottages, if you have a child that really wants to inherit it but is
Mhm.
unnerved by the capital gains, what is the best course of action that both secures the property rights for the person while they're still living, but makes an attempt to minimize the burden of the tax when they
So,
pass?
yeah, exactly. The burden of the tax is going to be on you, right? So that's what you have to provide for in your estate or now, if we're going to transfer it now, is if I have a cottage and I'm going to transfer it to my child, whether I do it now or whether I pass away, my estate has to pay the capital gains. I cannot avoid it, right? Or I have to pay it while I'm alive. I just did a transfer. I was speaking to a client today. We did it last year. And what the accountant had structured was we were going to transfer it now, so during the current owner's lifetime, to the two children. And we did it at fair market value. So there was land transfer tax on transferring the cottage. And the reason we did that is because of capital gains and potential double taxation. So if I gift you my cottage during my lifetime, there is a concern that you have acquired it now for $0. So I will have a deemed disposition at fair market value, and I will need to pay the capital gains tax when I give it to you. But then the concern is you acquired it at $0. And then you're going to have capital gains tax from your acquired cost base of $0 when you go to sell it or transfer it to someone else. So
So
the
let's just use
plan,
practical terms, just so that
yeah,
people, there was a whole bunch of terms. So you've got a cottage that's worth $1 million, which used to be
right,
laughable, but now that's many cottages
absolutely.
in many places of Ontario. So you've got a cottage for $1 million. You want
Yep.
the capital gains tax on that. If you were to die, it was to go into your estate and be passed on. Approximately a quarter of a million. Would that be like a fair round number ish?
So yeah, we have to look at what you acquired it for.
Yeah, let's say that it was you inherited it. So it was
Yeah.
or you paid $14,000, which
Okay.
laughably what many people did
Totally.
buy for years ago.
Yes.
But now you've got this $1 million asset. The capital gains on it could be 250,000.
Exactly.
In an attempt to avoid your beneficiary or the recipient of that cottage having to pay the capital gains on the property, you transfer it for $0 while they are still alive. But then the transfer value is zero. So when they go to sell it at some point in the future, they are now absorbing that $250,000 tax liability plus whatever the increase is between the time that they've inherited it and the
Well,
time
it's
that.
actually even worse because you pay the $250,000 because you were deemed to have
Oh,
disposed at it of it for $1 million, and then they again will pay the 250,000 plus. So that's why we don't want to gift it for $0 during our lifetime. We actually have to put a price on it. We cannot avoid that capital gain. So if I'm going to gift it to you, whether I'm alive or whether I'm dead, there is going to be a $250,000 tax bill that I have to pay when I'm alive or I have to pay when I'm dead.
got it.
There's no way around it.
You can't avoid them. I have
You
two
can't.
important questions that I think that need to be addressed just from the chat. The first one was, how do we set up a power of attorney for somebody that is a dementia patient? So, how do you establish legal documents for somebody that perhaps has already passed the threshold for establishing capacity? Am I explaining that right? So, somebody that
Yeah.
is already perhaps incapacitated, how do we put legal documents in place for somebody?
So unfortunately, that's when you need to go and do a guardianship because if they've lost capacity, they can no longer give a power of attorney. But you and I talked about this just before we started that just because someone has a diagnosis of dementia or Alzheimer's does not mean that they don't have capacity. We all know, we've experienced it with loved ones that someone who has dementia might really be with it at 11 o'clock in the morning. I can go see that client at 11 o'clock in the morning and she knows exactly what I'm talking about and exactly what she's doing. I can do a power of attorney. It doesn't matter that she has periods of incapacity. If she has periods of capacity, we can still do a power of attorney. But if there is no capacity, then you have to go to the court.
And so that's something that you should, this isn't you going to the courthouse by yourself on University Avenue. This is reaching out to lawyers like yourself that can assist with the preparation of those documents and the application.
Exactly. And that's the unfortunate part is you can do this free document that we, put the link in, or you can have a 6-month, $15,000 court application, and nobody who can take care of that person has the legal authority to take care of that person while we wait.
Unfortunate. And then finally, I want to just drop this bomb into the living room. Because this is our other family law seminar coming up soon, guys. This is the other very popular one. Do prenups override wills?
Prenups are binding on the estate. So whatever you agreed with your partner, it is binding on your estate. So yes, they are enforceable, and your executors your estate's bound by that. Yes, they're binding. So whatever you promised in that prenup, it will stand. It is binding on the estate.
So let me ask you a question. You sign a prenup to say, upon our divorce, you get nothing, spouse that I'm divorcing. If you are still married when you pass away, to be clear, it's not that the other person doesn't get anything. You were still legally married during that time. So the prenup does not override it in that, that they are not entitled to anything because you were not legally divorced. That person just died. So you're happily married at divorce at your time of death. It's not that the prenup overrides the will to say that you're not entitled to anything. You were still legally happily married.
So are you saying if you leave something in the will, even though you have a prenup, so you decide to leave something in your will for your spouse, even though you have a prenup saying everything's going to be separate? Is that what you're trying to say?
Your prenup precludes you, in case of a divorce, your prenup precludes any sort of spousal support. As an example, I'm just throwing that out there. You die, but you are happily married when you die. To be clear, the estate is still divided as if you were spouses. It's not like you're getting divorced at that point. Is that clear?
Yeah,
Yes.
that's right. Yeah.
Yeah.
And prenups can also deal with death, right? They don't have to just deal with divorce or separation. So it depends on what is in the prenup.
Great. We just have one final question. My brother passed away and he did not do a will. How would that work? So if you have somebody that you've lost recently in your life, there was no will, somebody needs to step up to deal with the estate, whether there was assets or not. What is the process by which, what is, step one, question one? It's to speak to a lawyer, correct?
Yes. And then we begin gathering an inventory of the assets, and then we can begin preparing if probate's required. And not every estate needs to go through probate, by the way. Not every estate needs to go through probate. To find out if an estate has to go through probate, you need to find out what the assets of the estate are. So step one is to make an inventory of the assets of the estate, and then take it to a lawyer, and then at that point we can make a determination as to whether probate's even required.
If there's a bank account, if there's a house, then we're going to need probate.
Yeah.
Got it. And I've got a question here from Mark. Sorry, just catching up on a couple. It seems like all these questions are coming in right at the end. In the early part of the meeting, you mentioned that you can name a person as a power of attorney and not let them know right away. How would that be possible? Wouldn't they need to sign the document as well that would allow them to accept being your estate power of attorney? That's a pretty easy one. You can answer that quickly.
Right. No, they don't know that you've, they don't sign it. They don't know. Some people don't even tell them. But the power of attorney documents are signed by the person who is choosing who will act for them. You don't have to, have the person who's been appointed sign the documents. And that's why you can resign, right? Like you can find out later, oh my gosh, my aunt named me power of attorney. I don't know if I have the capacity to take this on right now. So yes, the only person that signs the document is the person choosing who will act for them.
If the liabilities of the estate exceed the assets, is the estate executor liable for the difference if you choose to become the estate executor? Very common misconception. So you owe more than it. So somebody's afraid to step up because they think they're going to get stuck with a bill.
Exactly. No, they will not. They're not.
No.
They have to come up with the shortfall of the estate.
And to be clear, there are places in the world where that is a true statement. So it's a common misconception that has honest roots. So, and then finally is, I keep saying finally, my goodness, there's two really important questions. I want to just talk really quickly about the first dealings exemption because this is one that we see over and over and over again. So if you have a parent that has been in their house for a very extended period of time and there's been no
Mhm.
title on transfer, is it possible that there is an exemption on having the house go through the probate process?
Yes. So it's something that, so my main practice is real estate, Al's main practice is wills and estates. And we will work together on these. I always check them for realtors because that's advice that you can give to the client because they think they need to go to probate to be able to put the house on the market and they don't. It's a it's a rule, basically, our old land system didn't require probate. So if you bought the property many years ago when we had our old land system and it hasn't changed hands and it's still in a specific form of title and you have a will, if you don't have a will, we can't do a first dealings exemption because you don't have an executor. So we need to then do probate. But a first dealings exemption is we can sell the house without waiting for probate, which is um, markets are changing. You know, you want to make proper strategic decisions. If it's the right time to get the house on the market, we don't need to wait 9 months to get it up.
And then last question, I do promise, and then we're going to do our draw. Thank you everybody for being patient. So many great questions, guys. I'm so grateful to both of you. Should you attempt to navigate probate courts without the assistance of a lawyer? I know legally you can, but let's talk about the pros and cons of doing it that way. Obviously, some tax save or some fee savings, but what is the potential for misstep, and how does that play into this?
So probate is complicated. Um, there are a bunch of forms that need to be put together. There's a bunch of documents that need to be put together. If the application isn't properly submitted, then you risk the application being rejected by the court.
Yeah.
And so you're delaying the distribution and administration of the estate. And the courts are very picky. You know, if things are missing, they're very, very picky. And also
They
when
told me
you
once my font size was wrong and I needed to resubmit everything. But I wanted to add quickly, I'm very sorry.
okay,
I don't want you putting assets that don't need to go through probate on that
that's
form
right.
because then you're going to pay tax on them. So even that piece of what assets have to go through probate and which don't, if you don't have the ability to determine that yourself, you could be paying way more in probate tax than the cost of having a lawyer do the probate for you.
And we can show you what assets are probatable and which are not. And that way you get to save on probate taxes. So there's more for the beneficiaries.
Thank you. That's a great way to end things. So, Dave, I'm going to ask you to choose our winner, and we have had 95 people on this call for the entirety of it. Now, I know there was some discussion about changing your screen name. To be clear, Dave and I can see on the back end the actual names of all of the participants.
Okay.
And so you don't have to worry about changing your names. I can see all of the people. Dave, we're going to do this by like a wheel thing. Is that right?
Yep,
Bear with us
the
for a
share
second.
the green wheel, yeah.
Do we have a wheel? Oh, here we go. Okay, started screen sharing. It's like Wheel of Fortune, except it's a really good prize that somebody is guaranteed to win.
All right, here we go.
So this is everybody that is currently on the call. And if there's two people with the same name, to be clear, guys, I can Dave can determine which person we're talking about.
Oh,
So
I
the
love
winner
this.
is Tammy. We only have one Tammy, so this should be pretty straightforward. Congratulations, Tammy.
We'll talk to you soon, Tammy.
We look forward to
Tammy,
working with you.
congratulations. Wonderful. Yes. There's no cash value to this prize. So you get the wills and estates package and not a trip to Florida. But I just wanted to say thank you to all of you guys for attending. It's been our pleasure to chat with you tonight. Corman and Company's contact information is on this. You will receive a link to this recording so you can rewatch it, and also Kate and Al's contact information should you wish to reach out to them to get a second opinion or an answer to a question that you have. They do not only real estate law, they do not only estate law, but also real estate law. And what other kinds of law, guys? Just because you are a fairly all-inclusive firm.
We do some corporate, we'll do some commercial leasing. We don't do any litigation. We don't.
Family law, can we go to you for powers for family law issues, whether it's divorce or prenuptial agreements, or do you have someone you refer for that?
I have someone that I will refer for that. But you've got
Great.
somebody coming up too, right? For
Yes, we do have somebody
yeah,
as well too. But
fantastic.
you know what, guys, Kate and Al, just two amazing lawyers that we call on as real estate professionals very often to make sure that the information that we're sharing with our clients is sound. So thank you, thank you, thank you, everybody for attending tonight. Our next masterclass is coming up in mid-May, and it is going to be talking about insurance and the importance of having it, life insurance, critical illness insurance, disability insurance. So just part of that holistic approach that we have to making sure that you guys are making good financial decisions outside of real estate. And of course, if there's anything that any of us can do to be of service to you with anything real estate related, or if you know of somebody that's thinking about navigating this market, either as a buyer, a seller, a tenant, commercial properties, we are here to be of service. So thank you everybody for attending, and we will catch up with you again in May. Take care, everyone.
Night.
Thank you.